How's that?
Okay, I'm going to begin now then. So it's Tuesday, October 12th, Police Accountability Board's Regulations Subcommittee. Board members, myself as the chair, Michael Chang, board member Calavita, Julie Leftwich, Ms. Owens, and public member Saganor, I believe are all here. As a public advisory, this meeting will be conducted exclusively through video conference and teleconference. Pursuant to Section 3 of Executive Order N.2920, issued by Governor Newsom on March 17th, 2020, and to ensure the health and safety of the public by limiting human contact that could spread the COVID-19 virus, this meeting of the City of Berkeley Police Accountability Board will be conducted exclusively through teleconference and Zoom video conference, and there will not be a physical location available. You're accessing the site remotely. You can find the URL on the city's website. If you do not wish for your name to appear on the screen, use the drop-down menu and click on rename to rename yourself to be anonymous. To request to speak, use the raise hand icon on the screen. And there's also a telephone number to join that you can find on the city's website as well. If you wish to comment during the public comment portion, if you're on the telephone of the agenda, press *9 and wait to be recognized. Thank you. And so Acting Director Lee, would you like to call to order?
Well, you just did the call to order, basically.
Okay.
So
Sorry.
Next is approval of agenda.
That's right. So with regard to the approval agenda, I also want to make sure that I have a moment to provide a chief's brief update and regarding the city council vote on the interim regulations and conversation on the interim regulations of last week. Would that be an appropriate time to do so, Acting Board Director Lee?
You mean a chair's report?
Yeah.
You said chief.
I'm sorry, chair's report. Apologize.
I guess so. I mean, you can't really take any action, but if it's a report, you could report out.
Okay.
Or you could do it under agenda item 4.
Agenda item 4, old business continuing.
Which is an item. It's related.
That's true. What do you think?
It's your call.
Yes.
Let's do it under 4 because we want to have the opportunity for it to make a motion if necessary. Great. So we'll do that under item 4. So noted. Approval of agenda. Are there any questions about the agenda? Otherwise,
I'll move to approve.
Second.
any disagreements? Seeing or hearing none, motion is approved for the agenda. So we can move towards public comment.
I don't see any members of the public present, Chair.
Okay, no one is here. So seeing and not hearing anyone, noting that they are here, we will move on to old business. We're moving pretty quickly on the agenda. So I think we should start off with what I just discussed with regard to the chair's review of the city council meeting. So it's an opportune time. Many of you were there. So this council had a very long conversation with board chair Ramsey and myself as the vice chair of the board as a whole present with regard to the interim regulations. There was a lot of conversation on the items, in particular, the third item. The upshot is that the first 2 items, which you guys are familiar with, the fairly straightforward items, were approved by the city council, while the third one that I think you're aware of with regard to symmetry or having both the complainant as well as the officer, law enforcement officer, be able to speak to each other and see each other and ask questions of each other, it was determined that should continue on through the meet and confer process while we're also waiting for further guidance from the city attorney's office. Thus far, as you all know, we just have a pretty large or lengthy confidential memo, which we can't discuss in any kind of detail here. There was conversation about the necessity of having some transparency around the findings in that letter, as well as some form of possible public meeting for that. So from what I recall, that was raised as well in the city council meeting, which was also something that the board members raised at our last general public board meeting. So I think for today, there's a substantive and procedural issue that we should have a conversation about to ensure that everybody is on the same page and we understand what type of authority we have currently. So in particular, with regard to that symmetry issue, there was a Berkeley side article that acting board director Lee sent out, which seemed to indicate that that reporter's perception, at least, was that the current status is that the current slate of docketed cases would be treated as if there were no right of the complainant to quote unquote cross-examine, which is not a great term, but to question the police officer. So I want to open up conversation about what the intent of the council was and to determine what the next steps would be. As the implication in the news article does not seem to align with what I understand to have been the conversation, unless I've misunderstood. And I'm assuming that for some other board members, that might be the case as well. Board member Calavita has raised her hand.
Yeah, so I just read that article this morning and spoke to Kathy about it because I was really confused, and I actually thought that Berkeley side had gotten it wrong, because it was my understanding that what happened at the council meeting was that they passed the board's version of interim regulations with the exception of putting on hold the third substantive change, let's call it, where the complainant would be allowed to remain in the room pending the city attorney's analysis of the legality of that. Pretty clear, I guess, that it would go to meet and confer, but we're waiting the city attorney's analysis of whether that would be legal. And so city council, it was my understanding that put that particular one on hold, but there was not a vote to revert to the old PRC version for that topic. And so I was surprised when I saw Berkeley side reporting that for the pending cases, until we have a new regulation, we would revert to the old PRC practice of dismissing the complainant when the officer testifies. That was not my understanding of what they did. I actually went back and listened, watched the video of the meeting, and didn't see anywhere where they voted to do that. The only thing they voted on doing was to put on hold the PAB version, waiting for a legal analysis. So, and in fact, I thought that it was implied then that we were in a little bit of a limbo situation, and there was discussion of what do we do about the pending complaints. And apparently there aren't any complaints that will immediately crash the deadline. So that conversation about what do we do about the, also says to me that the assumption in council was that for the moment we're in a holding pattern. So we just have to be clear on this, because it was completely not my understanding that we were going to revert to the PRC practice. And I don't know what other people who were there. I spoke to Kathy about it, and she and I had a different understanding of what had happened. And so I don't know what other people on this subcommittee who were there or watched the video and how we proceed.
Thank you, Board Member Calavita. I'd like to give the opportunity to Acting Director Lee to speak. Her hand was next, and then Ms. Saganor, and then Board Member Leftwich.
I did have draw a different conclusion from the council's vote. And I want to be clear, first of all, that Emily Ragusa, who wrote the Berkeley site article, I did not have a conversation with her on that topic. I did email her about the correcting the percentage of sustained complaints. So we had email communication about that, but I did not in any way influence her interpretation, which is consistent with mine, which I think is consistent with the departments as well. Because if we did not, I would not have left that meeting without having a complete set of regulations in place, because that's my goal, is to get our investigations going. And I do not think that the union would be sitting for interviews as they are right now if they thought that there's no provision in place currently regarding how the hearings will proceed, and specifically the complainant's role. So that is what I have to say about that. Chair?
Thank you. Yeah, sorry about that. And thank you, Board Member Lee. And so next I want to go to Ms. Saganor, and then Board Member Leftwich, and back to Board Member Calavita.
No, I'm lowering my hand. I didn't mean to keep it up.
Okay, thank you.
I heard at the council meeting, and now I'm going to try to check the annotated agenda and see what it says there. I heard them say that they were putting it in abeyance. Am I right? Was that the word that was used?
They used that first, and then they said defer consideration. And I think that's the language in the annotated agenda.
Yeah,
Okay.
our suggested change was put on hold, in abeyance, deferred, whatever.
Consideration. Okay. Well, so yes. So my understanding is that they left that they did indeed leave that question open, and I actually was wondering how the department was going to respond to that. But since they left that question open, and since this is the Police Accountability Board and not the PRC, it doesn't revert back to something that the Police Accountability Board has never done. That's where I see the logic of this. They've deferred it and they've left it unsettled, and there isn't something to revert back to because it's a different organization.
I believe it was reverting to my recommended language.
Okay, thank you. Board Member Leftwich.
Well, I understood that evening that they were putting it on hold, deferring consideration, putting it in abeyance, whatever that means. But I can see that they left a certain amount of ambiguity about what that even means. So they should have been more explicit about it, and they weren't. Because it could mean then reverting back to the provisions that Ms. Lee submitted, but they didn't say that. But if it's in abeyance until the end of meet and confer, that's kind of was implied, but who knows how long that's going to be. And so that means there are no regulations in effect. So at the time I was just thinking, okay, it's on hold, without going the next step of what does that exactly mean. So I think it's ambiguous.
Thank you. There is some ambiguity here that we're trying to get clarity on. And I want to go to Board Member Calavita.
Yes, I I do think if they, I mean, they did not have the vote about going back to, you know, taking from Director Lee's document that particular piece of it and voting on that. So I think it maybe was an oversight on their part. I have no idea. But the PRC no longer exists. And so in the absence of an active vote to use the old PRC regulations regarding that would be odd. So I don't know how we proceed, but I don't think, I mean, I don't know. Maybe we're all seeing this through the lens that we prefer to see it through. But what I do know is that the council did not vote on reverting to the old version. I mean, I looked at the meeting again today and they did not vote affirmatively on that. So I guess if one assumes that the default is to go back to the PRC regs, then that must be the thinking of those who believe that. But the PRC is a dissolved organization. So I just, I guess I don't know what we do from here, although, there is, I don't know.
Thank you. So we are trying to get some clarity on this, and we don't have specificity on, I guess, for lack of a better term, the legislative intent from the minutes and from the video. They don't appear to reveal that. There seems to be some space here that we don't want to. I think we have to be careful about, us inserting any type of assumption there. In particular, Board Member Calavita is noting that a presumption that the prior PRC regulations are in place could be rebutted by the fact that the PRC no longer exists. So I think this is a very important conversation to have out in the open. Investigator,
Maybe we could write a letter to the city council requesting clarification and just saying what our understanding is and that there's ambiguity, because we can't decide ourselves. We can say what our understanding was.
Sure, that's certainly a possibility. You could consider a motion, Board Member Leftwich. I want to make sure to go to Investigator Norris.
Oh, sure. Go ahead. Go ahead.
I don't know. I watched the city council meeting and it seemed to me, and I could be wrong, that it was the intent of the council to resolve the issue of not having regulations in place for our board. And they had in front of them the director's recommended version. They had the board's recommended version. And the only difference between those were the 3 items that were before the board. They approved the 2. And it just seemed to me that it was clear that the council was interested in moving the complaint process forward, not forestalling it. So, I mean, I understand to a very minimal extent that maybe perhaps things could have been more explicit, but I think the council's intent was clear. And also to say that we would go back to PRC regulations by default, I don't think that's an entirely accurate description. I think we'd be going back to longstanding practice, city attorneys, opinions of how these hearings should be conducted, and specifically in regards to the complainant's role. I think that the automatic default is until the council resolves that last question, the complainant can't be in the room during the officer's testimony. And that's based on, again, city attorney analysis, based on state law, based on longstanding practice. But if we go down this route, we're going to shut the complaint process down again, I think. But okay, that's it.
Thank you, Investigator Norris. And I want to go back to Acting Director Lee.
You just say Ms. Lee, it's less of a mouthful. I don't think you can vote on this tonight. It's not agendized. But tomorrow night, on tomorrow night's agenda for the full board, I did agendize, I forgot what I called it, but something about the interim regulations that the council passed. So it would be appropriate, I believe, for the full board if they wished to write a letter seeking clarification to from the council to do that. I forgot to mention that I have an email into the city attorney expressing this concern, and I have not heard back from her.
Chair?
Yes, please proceed, Board Member Leftwich.
Oh.
Did you have a proposed motion?
I thought Ms. Lee was saying that because
Yes.
we didn't agendize it.
Oh, I
that-
see.
Yeah, I don't think you can vote on this without violating the Brown Act.
I see. Even under the agenda item number 4, the old business with regard to continue drafting permanent regulations and also update on pending questions to the city attorney.
I'm sorry, I don't see it falling under either of those.
Okay. You're saying it has to be more specific than that.
Yeah.
Okay, so the director has spoken with regard to her expertise on process and procedure. So we would then need to agendize it for Board Member Calavito. Were you about to say something?
Yeah, I just wanted to add that there was quite a conversation about pending cases and asking Director Lee how many pending cases there are we up against a deadline, all those things. And it was my assumption from that conversation that that was about the risk of putting this item on hold. Like if we were going to go back to the old practice, then I don't think that they would have had that concern about what do we do in the meantime. That it seemed to me that there was quite a discussion about that. But anyway, I guess so. Ms. Lee, what are you suggesting we bring up tomorrow night?
The same thing.
Right,
Well,
but I mean,
maybe in Chair, in your report tomorrow night, or at some point, just say that we discussed this and it wasn't agendized, but that our recommendation was going to be that we, send a letter requesting clarification. I mean, we can talk about what we talked about here tonight, even though we don't have a
Yeah.
formal motion. Right?
I think that's a good idea. Would you guys agree with that?
I mean, basically, yeah, I'm suggesting that you could have this same discussion tomorrow night with a vote, because I have agendized the interim regs as passed by the council.
Right. We can say we discussed it tonight.
Yeah.
Yeah.
Okay, and let's do that. If it looks like everybody agrees, I don't see anyone shaking their heads, or mostly everyone seems to be nodding their heads. So let's do that, and we've requested for Ms. Lee to agendize for our meeting, and in the meantime, with some clarification requests. In the meantime, is it still appropriate to proceed with our old business, which is to continue? Well, number one, maybe we should still, since it's on a related topic, any updates on the pending questions to the city attorney? It doesn't appear like there are such, but Ms. Lee.
No, sorry.
Sure. So we want to continue to remember that we as a board unanimously had asked, and also in the regs committee had asked that the city attorney provide an opportunity, and also in terms of a public meeting and potentially a closed meeting to have a conversation on the issue regarding the confidentiality, but also the substantive legal questions, and also to have some form of publicly available and published documentation. And there was some commentary at the board about, publication of general legal standards without naming an officer or other confidential type of issues. That there's a concern that was being drawn within the scope of confidential legal analyses. So that is one of my
Quick question. Do we know if we received the same analysis that the city council received? Because
Yeah,
if it's
I'm
it
assuming
was
so.
identical. So then I could discuss that with my council person without violating any. Okay.
Yeah, that's a good question. That is correct. Board member, Ms. Aguilar?
So did the city attorney get the request for providing some kind of publicly acceptable
yes.
information? Can
Yes.
you tell me when that was sent to the city
I think
attorney?
shortly after it was requested.
So about
It's-
two
it's
weeks
been-
ago.
Yeah, exactly.
And the city, and you've heard nothing back from the city attorney in terms of, yes, I could do that someday, or,
I have, she's acknowledged, I reminded her that those topics are agenda. Last week, I reminded her that the topics were agendized for tomorrow night's full board meeting. And she said, and she acknowledged that, but didn't give me any sort of time frame.
okay, thank you.
But in the meantime, there's nothing preventing this group from carrying on with the,
Yes.
Right, let's go.
Let's
Yes.
go.
So we proceed with 4A. So where were we again in the regs?
we were at,
Page 9 from last week and page 8 from this week.
right, thank you. And would you like me to share screen?
Sure, yes, please.
Could I raise a couple of questions that come before that based on the council's vote?
Okay,
Ms. Lee, so under who may file, which is on page 4 of this week. Only aggrieved parties as well as eyewitnesses, parens, percipient witnesses. That
yeah,
was added by the council.
right,
But then the following sentence about the board filing based on 5 members voting. The language here is not the language that I think you suggested was passed by council. The council didn't say anything about available to, didn't it say simply, according to the version that you distributed, council simply said the board may initiate complaints based on the vote of 5 members or some such thing.
right.
I just
Complaints,
want to get the language exact.
complaints may also be initiated by the board upon a vote of 5 board members to authorize an investigation.
So we should change that language in tonight's, do you see what I'm saying? Who may file, the council changed our language a bit,
Right,
so that should change there too.
yes.
So that's
good
one
idea.
thing. Another thing is on page 6, production, subpoena, and preservation of records. Page 6, number 6. The charter gives us the right to issue subpoenas to compel the production of books, papers, and documents as needed, but it also gives us the right to subpoena to compel the attendance of sworn officers of the BPD. So I would add there, if people agree, that we might as well take the authority that the charter has given us to issue subpoenas, not only for documents, but for people. The charter makes that very broad. It doesn't say, it just says any persons, but I would say the director and the PAB, the charter includes the PAB in this, the board. The director and the Police Accountability Board may issue subpoenas to compel the attendance of sworn officers of the BPD and the production of books, papers, and documents as needed to carry out their duties and functions. That would be my motion.
I'll second that.
Oh, okay. I'll finish typing. To compel the attendance of sworn officers and
And then, as it says there, the production of books, papers, and documents is needed to carry out their duties.
okay, don't you want it to be broader? If your intent was to be as broad as the charter amendment, then you would say, compel, anybody's attendance. Don't we?
Persons, maybe.
You know what? I actually would not want to include the attendance of civilians, because Councilmember Taplin raised the objection, and I think it's a correct one, that if eyewitnesses are going to file complaints, we don't want to compel the aggrieved party to attend. I mean, if we want to say the attendance of city employees or something, but I would feel uncomfortable compelling the attendance of civilians.
We don't have to, though.
Right.
I mean,
right.
we could say the attendance of persons or of individuals and leave it at that, just knowing that we probably wouldn't do that, but it preserves, because you never know, what circumstances might come up.
That's right. You never know.
You never know, but on the other hand, Chair Ramsey was able to push back against Councilmember Taplin's concern that we might subpoena an aggrieved party who was reluctant to appear. And Chair Ramsey said, well, our regulations only talk about compelling the production of books and papers. And so I don't know. I'll go along with whatever people say, but
I just want to, oh, go ahead, Board Member Calavita.
no, I was just going to say, I know that the charter says persons.
And just to contextualize that, and then Board Member Owens, I think there is a concern from Councilmember Taplin that somehow there could be circumstances where an unwilling witness would be kind of forced into a situation where an incident involving them would be investigated without their consent. And so I think that's a pretty rare situation, but the reason that we were talking about that is also to provide the opportunity in a case where that there could be potentially a broader issue that could indicate some concern with regard to police practices, which of course, again, these are all just procedural and questions on principle. We're not saying anything about the police department or their practices at all currently. It's an aspect of providing investigative scope, and that was my understanding of it. And so, Councilmember Taplin's concern, I think, it was responded to by Chair Ramsey's comment pretty efficiently, but I do want to remind folks of that very specific context. Board Member Owens.
I believe we should leave this broad and put persons. I don't think, as was addressed at the council meeting, I don't think this board's intention is to force anyone to do anything against this will, but I don't think that we should put in our rules and regulations something that's narrows down the authority of the board. So, I think we should leave it as it is in the charter, and and go with that. That's my opinion.
Well, if that's the opinion of subcommittee members, that's fine. So I would rephrase this: the director and the Police Accountability Board may issue subpoenas to compel the attendance of persons and the production of books, papers, and documents as needed to carry out their duties and functions. That would be consistent with the charter amendment and presumably has already been meet and conferred over by the union.
Okay, do we need to
Yeah.
modify the motion?
Oh, just a quick question, Kitty. I'm looking for the section in the in Measure II. Does it say in reference to subpoenas, does it say the director and the PAB, or does it say the
It
director?
does. It does. It's in the charter number.
Well, what I'm asking is, does it specifically say and, or does it say or?
It says and.
It says
Okay.
and,
It's in
Okay.
20C.
Okay, that was my question. Thank you.
as
Okay.
well as 3.5, but yeah.
And that, for lack of a better term, that creates some symmetry between the investigatory authority of the director and the PAB, which obviously the PAB has certain executive discretion, but in terms of investigatory authority, in general, the practice, I think, with independent bodies of this sort, you want to have some parity, so to speak.
Yeah.
Board Member Calavita, did you have a comment? Your hand
No,
is.
those are the only two things that happened before,
Okay,
before where we got last time.
Okay.
okay.
Do we need to?
Chair-
And we don't need formal motions, right? Did we decide we can just, we
Okay,
don't
good.
need a motion and a vote on every single thing?
No.
Yeah.
No.
So any
Chair-
any
Chair-
disagreement doesn't seem to be. Yes, Kathy.
Could I point out here in this section 7, it says, I didn't put in the authority here, but it says subject officers and witness officers must appear for interviews related to complaints. So that was the section in which that was my intent there, is to reflect our ability to require officers to come for interviews.
Mhm.
Okay.
Okay.
Is there something and I think folks seem to be in agreement with acknowledging that. Is there anything you want to change about it? I think it looks fine. from
I
what
don't think so.
Okay, Board Member Leftwich.
Well, I was just ready to move on. So I had a comment going forward if we're ready for moving on.
Yeah, I think we're ready.
Okay, so
Okay.
section E, which is on page 8. Time to submit, it says that if the board requests it, that we shall convene a confidential personnel hearing. And so I read this and I'm thinking, what if the director thinks there should be a hearing? Because there may be close cases where the director says, it's not obvious to me, we should have a hearing. But the way the regs are written, it seems to suggest that the director has findings. And then if the board doesn't accept them or thinks that we need a hearing, then we can request it. And my suggestion would be to say, if the director or board requests it, and just to envision the time where maybe the director would think a hearing is appropriate.
What number are you referring to?
E1.
E1,
So where in
And
that
then
director, so after the director, it
Okay.
says the director and the board must submit and present. Is that right, or am I in the wrong place?
we're right there. That I,
That's,
Yeah, hearing if the
Oh,
board,
if the board or director requests it, you're saying.
right. And the other
Yeah.
thing, just kind of a big picture issue, is that the charter amendment, section 18B on page 66 says, the Police Accountability Board shall hear and decide findings on allegations of misconduct. You know, and the police department must appear and testify. And so I just feel like there's inconsistencies with the way Measure I was drafted,
Yes,
which is
can-
unfortunate.
Yeah,
Yes.
but we can, in
Yes.
our permanent regulation draft here, language, we can try to, which, as you guys understand, we can iron that out, those inconsistencies in proportion with the intent. And then, obviously go before a full board review and further process if necessary. So I think that's fine. And so we can continue to see where there are inconsistencies and make sure that to prioritize those, to even those out. For right now, though, board member Leftwich, do we want to add then if the board or the director requests it?
Yes.
Okay,
I
And
think
then
that's a
just
good idea.
yeah, I agree.
Request, not if the board is that requests?
Can
If
I,
I want to make sure, yeah, board member Owens hasn't had a chance to speak yet. Her hand's been up.
so I'm looking at the charter, and the chart, that's written as the charter is written. The charter does not give the director the ability to decide
So-
that he wants to do invest in.
Do you think that's an oversight or is that
Yeah,
intentional?
we can't guess whether or not it's an oversight. It's what's documented, and that's what we have to go by. We can't assume anything. We have to go by what this charter gives us the authority to do. Is that correct?
Well, but it also gives us the authority to hear and decide findings. So I think the charter is, it's not well drafted in some respects.
That's
So-
true.
Yeah, I mean, we're kind of in a situation where interpreting some of the intent, and I understand board member Owens' hesitancy to maybe over determine that. So, I mean, we could put that in there and put a flag there that the charter says something that appears to intend something different, more limiting in scope, but our intent is not to,
Well, it does seem, Chair, that you're giving the director more authority than what the charter gives. And you have to contemplate what's intended here,
Mhm.
as I think. The director presents those findings to the board and the board decides whether to go forward with a hearing. But now you're saying the director will present the findings and decide that there's a hearing. I mean, they have different roles.
yeah, no, that's a good point.
And I think that you are changing these roles.
So if there's a
I-
substantive
And
change,
more importantly, as board member Owen said, I don't think we need to be adding to what the
director's authority is.
charter amendment says.
Yeah,
I would like to throw this out there, which is if the director comes to you with findings and recommendations and says to the board, I just don't know. I really think a hearing would be incredibly helpful.
right.
Can you imagine the board not?
No, no,
Sure, yeah, no, that
So
makes
I
sense.
think the director, I appreciate board member Owen's comment, which doesn't really say the director, and there would be some, I would have a question as to whether this is contrary to what the charter is saying, and
Okay.
at the same time, I think as a practical matter, it's probably not necessary.
right.
If your director comes to the board and says,
Yes,
I really think you should have a hearing. This is my recommendation. Here's my recommendation on the findings, but I'm not sure. And one of my recommendations is, I think you should have a hearing.
yeah,
Okay.
Really useful.
So
I
let's
agree with
assume-
that.
Let's assume like moving forward when we're trying to hammer out situations where we may be stepping on the intent of the charter. Unless there's substantial, in other words, very strong evidence that it was due to an oversight, that we don't want to change the balance of scope of authority between the board and the director. To try to bear that in mind. That could be a good kind of yardstick. So,
Mhm.
I've got something else on that, in this section, back to categories of findings, which we discussed, I don't know, a month or so ago. So this whole section is about what the director does, right? So I was thinking in 3, it would be good to say, the director's recommended findings shall include one of the following categories. And then we have the categories without that precatory, if that's the term, language, if the evidence shows. Get rid of that and just keep what we have in red, but tie it to the director, because that's what this section is about. But then we also need to later on reference these findings, because later on, if the board has a hearing, we need to revert, cross-reference these findings, because this is just about the director, right?
I don't know if that's the case. I mean, once the board takes over, I mean, Kathy, you might want to weigh in on this, but I don't know if this is limited to the director's actions.
No, I'm just saying the way this is structured, the way this fits within the regs, we're talking about pre-hearing complaint disposition, that it's talking about what the director is doing, right?
Yes.
I mean, it's under E, and it's talking
Right.
about the director does these things, makes recommendations. So I just think it's more clear if we say that the director's recommending findings shall include one of the following categories, and then we do A, unfounded, B, not sustained, C, exonerated, D, sustained. And then later on, and we can do that when we get there, it was on page 18 of the prior version, we talk about deliberation and findings, but then there's no reference back to the findings. And I think just for clarity, later on, and we can do that later, we should say that the findings shall be the same as, under section E, whatever.
I think you're right.
What are other feelings here about that? Board member Owens and Ms. Saganor?
Somebody point out where in the charter it says that the director. Oh, okay. I answered my.
Okay, you found it. So can you,
Okay.
everyone else agrees, would you like to tell Director Lee what the changes would be?
One more time.
Right. So below categories of findings, I don't know if we need an A, but the language would be the director's recommended findings shall include one of the following categories.
Okay.
Because this is called categories of findings. Yeah. And then
Right.
get rid of what we have as A. And A now just becomes unfounded, the definition. So now we're just using definitions.
All of the red print.
Right. But get rid of the stuff above the red print.
Yeah. I thought that was what we had agreed to when we discussed this.
We did, but I didn't have the introductory language that kind of tied it together. And then the only other change on that should be B, not sustained. At the end, it should just say, or it should say, the available evidence can neither prove nor disprove whether the alleged actions of the police officer occurred. And that's just to make the phrasing consistent with A.
Okay. What do you guys think? I think that looks good. And it's already been reviewed, and previously, the red is there already. We're basically revising the additional revision that we agreed to at the prior meeting, from what I recall.
So my question, we're gonna go back in and put the ABC for each.
That was my question too.
Yeah, that
Right.
would help.
Okay,
So A, just
I'll
really
do
quickly,
that.
A would be
A could
unfounded.
be unfounded, right?
yes.
And
Thank
B
you.
is not sustained.
Thanks, Kathy. And just a time check, just to remind everybody, it's 7:30 right now, and we wanted to keep to 2 hours each time we have these subcommittee meetings, and we're going to have a number of them as we work through this. So that means that we have about an hour if we're sticking to the 2 hours. I think we should try our best so everyone will be fully rested for the next one.
Can we talk about where we're now going to insert reference to these categories, board member Leftwich? where does that now go for the
Okay.
board's findings?
Well, I was going off my old version, which was page 18 of last week's version, and then I was having a hard time finding it on this one because it looked like things were moved around. It's under deliberations and findings. So wherever that was, the old section L from last week.
Okay,
So wherever.
so it's page 16.
Oh, yeah. 16, number 5. Is that right? After the hearing has concluded. the
Yes.
panel.
Oh, so we changed I guess we definitely changed the format from last week. Because before it was an L, deliberations. and
Yeah,
findings.
I had a, oh no, it should be L. I don't know why it says K. This,
Oh,
Is
wait.
it-
okay.
L.
We talked about it.
So now it says 5.
Yeah, now it says 5 and printed.
Well, that was, yes, that was, I thought I fixed it, but
That's okay. So
yeah,
what do
the
you want?
version I sent
to be
you
L?
was not right, and I apologize for that. It
Hearing
was
panel
just,
from
you know, when you accidentally delete one of the numbers or the headings and
Yeah.
you're auto numbering, then everything changes, so.
So should that be K then, or should it be L?
Or I, or I.
Because it seemed to be I in the printed version.
Deliberation,
this
no,
week.
it should be K, actually.
Can we just let Director Lee figure out the?
Yeah, you can
letters
do
and
the,
things?
Yes.
sure, you can
I
handle
think
the
you, Kitty.
lettering.
It needs to go under the deliberation section. After the
Right.
hearing is concluded, the hearing panel deliberates outside the presence of everyone except ODPA staff. The
Okay,
hearing panel shall not consider, oh, I'm sorry, it's the vote. The hearing
Vote,
panel shall
right.
affirm, modify, or reject the findings and recommendations of the Director of Police Accountability.
So maybe we don't need anything, actually. Maybe that's enough.
Well, they have, but we
Oh.
have to not only, affirm, modify, or reject, but we might say using those same categories.
Yeah.
okay, so what language would you want to add there? Using those same categories?
Vote.
That suffice?
The hearing panel shall affirm or reject the findings of this.
Or we could
Um,
say as set forth in section and just cross-reference the earlier section.
Yes,
I
think
think
that's
it's,
fine.
Why don't we do that?
I think it's clear.
So Investigator Norris feels that's clear. Also, want to
And
make
I do now understand what you were doing, Board Member Lethwich.
Yeah.
at the
but we
first
need to
part.
delete,
But I don't think you need to make this clearer, this section.
Ms. Lee, we need to delete reference to the article, right?
that's been
Yes.
seated already.
I just did that.
Oh, okay. Well, there's no harm in saying as set forth in section
Right.
so-and-so.
Right.
Might as well be clear about it.
Okay, why don't we put that in for now, and then just bear in mind, we don't want to clutter it up too much, but I guess that's not harmful.
Too late.
Ms.
I'll go
Saginaw
back
has
to
had her
that.
hand up for a while, though. I want to make sure that Board Member Lethwich completes her.
That was it.
Okay, and then, okay, Ms. Saginaw, did you have a comment?
Well, I hate to mention this again, but I'm still worrying over the language about sustained and not sustained. And that when not sustained is in capital letters and both words are in quotation marks, that means one specific thing. If the not is in lowercase and outside the quotation marks, that means something different, right? There are 3 different things that are not sustained, but only one that's called not sustained. And I don't see a way to solve that, but it does mean that when something is read, right, you can't really hear those quotation marks. And so to know that something was not sustained, you don't know whether that's just ruling out the sustained category.
I don't think we have quotation marks, do we?
Are you're
Well,
reading like scare quotes?
We
So-
had,
Yes.
if you look at what was crossed out, there were quotes.
But we
Right.
don't have them now.
Okay, well, now then all you have really is the capitalization in some sense. You know, you see what I'm saying, I'm sure.
No, I actually don't.
So
I don't-
it's not in this document, But in discussions about what is going on, if I just say to you, if you say, well, what was the outcome? And I say, well, it was not sustained. You don't know whether I'm saying the outcome was not sustained or whether I'm saying the outcome wasn't sustained. It might have been exonerated. It might have been unfounded. Unfounded and exonerated are not sustained, right? We have a two-value logic system,
Oh, I see.
right? And if you're saying something either is sustained or it's not sustained. And then if it's not
Right.
sustained,
We're-
it could be
we're-
unfounded, exonerated, or not sustained. And so
We're stuck with these.
I
categories.
know that you are. And so as I said, I hesitate to even mention it, but
Sure.
it will definitely lead to confusion. I'm presuming that
Well,
this originally developed out of just a two-value where the choices were not here, but in the state. This choice was sustained or not sustained. And then these two other options got added along the way. But the not sustained one didn't get renamed in a way that distinguished it from.
And it
Yeah.
is in the charter amendment. So
I know it is.
unfortunately, even though I would prefer basically a thumbs up, thumbs down, we're stuck with these. But
Right.
I do think that when we get later on about describing the outcome to the complainant, that I would like to see us flush things out a little more, because just saying not sustained or unfounded, it's very confusing. So
Sure.
I
I
think we
recall
can
that
deal
we
with
had,
that hopefully later
think we
about
had-
when we say what's communicated to the complainant.
I
Okay.
recall talking about a brochure of some sort, if it's not already there, and just making sure that there's a public
Right.
document, like a very simple flow chart. I think Investigator Norris said there was one, but maybe we could revise it. I'm trying to recall.
What I
Okay.
said was that
Yeah.
staff would work to ensure that the letters that go out from the DPA would explain these findings to make sure that there's no confusion. Yeah,
And then we could have a public document too, a brochure of some sort, so that members of the public, they can just go online and there it is, as a flow chart. That's very straightforward.
Well, and the complainant should get it in advance too, so that they can, have some time to study it and understand it rather than getting it after the fact. I mean, that would be a nice packet to give the complainant,
Right.
It also
Yeah.
might be that when we do our annual, or when the director writes the annual reports, I know a lot of people see the annual reports and see how many complaints and whether they were sustained or not. And when they're all not sustained, it really does send the wrong message. I think when we say not sustained in those annual reports, we might include the evidence could neither prove nor disprove, or
Right.
something like that. Because all of these not sustained makes it look like the officer was exonerated.
right?
Yeah. So
Yeah.
in other contexts, just as an aside, then we should move on. In other contexts, the language is oftentimes dismissal. I think it's because we're in a criminal context, but we're not in a criminal context. We have law enforcement who work in criminal law, but we're applying like a civil standard in terms of an independent commission. That's why the language is a little odd. But in civil context, it's typically it's a dismissal, and then inside of the determination, there's a description of a whole bunch of various protocols for why it was dismissed: untimely, or insufficiency of facts, etc. So we have what we have, but I think just the communication aspect will clear that up. But I really think a simple flow chart, which is what we do at my agency, that I know that Investigator Norris sends out something as well, but some type of flow chart that describes, the different types of unsustained might be helpful, but also to post it online too, so people don't have that perception that we're just throwing out cases. And that as Board Member Calavita noted, that it means that the evidence indicated that there was no merit to the complaint, I guess would be one way to describe it. Great, sorry about that. Should we proceed here?
Yes,
Uh,
yes.
Chair, very quickly, in the annual report, I just brought one up, pulled one up. I do talk about the 4 categories in the complaint when I talk about the complaint process.
Yeah, I thought you did.
Yeah, it's just that sometimes people summarize the complaint chart and
Right.
it just seemed to me that maybe even when you, anyway,
To
I think-
maybe repeat it when we get down. to
yeah,
the-
when you,
Yeah.
yeah,
Yeah,
It's just a communications issue. I think you
Yes.
guys are doing a good job with that. It's nothing about whether you are or aren't.
yeah. It's
probably
just that
more-
the public might, don't get the wrong impression.
Yeah, more of it more often on the website and in brochures is my suggestion, but we could always tackle that later. Great. So where are we now? We are,
After the categories, I had the insertion of one word or two words on page 10 under number 4,
okay,
obligation to serve.
obligation to serve.
At the very last sentence always confused me. The
Constitute,
notice of challenge of a substituted board member must be made at least 3 business days before convening the hearing and constitutes good cause for continuing the hearing. I never quite understood and constitutes good cause. And I would just add, and said notice constitutes good cause for continuing the hearing.
and said notice.
The notice of challenge,
Okay, and
blah,
said,
blah,
so
blah, and said notice, or, yeah.
do you-
yeah.
I think the challenge itself is what constitutes good cause for the continuance.
Okay, then, see, I didn't understand what it meant. So said challenge constitutes good cause.
okay,
Is
said
that-
challenge constitutes good cause. Can we add that and just to take a look at it? The notice of challenge of a substituted board member must be made at least 3 business days before convening the hearing. And said challenge, which would be the challenge of a substituted.
Or to make it more clear, and that challenge
And
constitutes.
that challenge, yeah, it said it's a little bit. And that challenge constitutes a good cause for continuing the hearing. Okay, I think
What?
that's pretty clear.
Wait a minute.
Oh, yeah. Uh-oh.
That's not what it
The
means?
the good cause is referring to, oh, let's see, 1 second.
Continuing a hearing.
Board member serve on blah, 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 if hearing, blah, blah, blah. If substitute days,
I just never understood what that sentence meant.
immediately 3 business days.
I don't understand. I don't understand what that means.
But that last clause is a little confusing. So it does say to me, the first part of it, 3 days before the convening of the hearing, you need to
Right.
challenge the substituted board member. But the second clause is that challenge then constitutes a good cause for continuing the hearing, which,
Maybe it
Doesn't
just
quite make sense.
results in a continuance, that it's not,
yeah, and that challenge results in,
Well, the challenge, the board itself, I believe, has to make that decision.
Right. So the challenge has to
So the
be,
good cause is a standard, right,
okay,
Kathy? I mean, what they're doing, they seem to be lumping in 2 different processes in that last sentence.
so we
The
break it
notice-
apart into 2 sentences then.
The
And the third
notice and then what's required for the
yeah,
continued
maybe do
hearing.
make it in 2
Let's
sentences.
break it into 2 sentences then, like, so after the hearing, put a period. You guys tell me if that makes sense. At least 3 business days for completing the hearing, period.
Yeah,
And then take away and then becomes that challenge that we have to work with the language of, but that challenge, the board then determines if that
yeah, what does
challenge,
this, what
It's
does
either
this mean?
I don't know.
What's supposed to happen here?
What is the actual authority here?
Kathy, let's talk about it. Now, we've had this,
I
Yeah.
think it means, I think we have to go to page 12 when we talk about hearing continuance requests. And here we say, director may grant the request only for good cause.
okay,
So I think what the phrase above was saying that is that a challenge to a board member is always good cause. And that the
doesn't the
director,
challenge have to be affirmed as valid?
No, I think it sounds like it's just the fact that it was made.
right. We're talking about good cause for continuing the hearing. We're not
Okay.
talking about the merits of the challenge. We're just
Okay,
talking
and
about,
so, well,
Oh,
we
wait,
don't really
okay.
need 2 sentences. We can just say, and that challenge constitutes good cause for continuing the hearing.
I have a suggestion on this.
Yeah, thank you. Please go ahead.
When you're talking about the good cause for continuing the hearing, that's when someone has requested continuance of a hearing, right? And here, the request, it's not a request to continue the hearing, it's a challenge. I'm not
Right.
sure that you need to reference the good cause article. Why wouldn't you just say, must be made at least 3 business days before convening the hearing, and then say, the hearing will be continued until the challenge can be resolved, or something of that nature. It's just a procedure at this point, rather than a request to slow it down. It's a procedure that you've got to figure out what to do about the challenge before you can go on with the hearing.
Right. I like that.
Yeah. Okay.
That's good.
okay, so I'm sorry, it made sense, but what did you say?
Okay, so you've ended the sentence out after the notice must, the notice of a challenge must be made 3 days before convening the hearing.
Right,
And then you would say the hearing will be continued until the challenge can be resolved, or words like that. It's a procedural continuation of the hearing rather than a response to a request for continuing the hearing.
Right.
That's
Right.
good. You need to note there that can be resolved by the board or something like that.
Oh, sure.
No?
You probably need more than
Is
that.
it- Oh,
What do you think?
I think that's clear the way Ms. Saganor put it.
Okay, just leave that resolved and just assume that the board obviously will be managing the resolution.
Yeah, but you know what? Does everybody everywhere understand what continue means? Like the hearing will be continued. Most
Hopefully.
common language, yeah, if you're a lawyer, but most people will think that means that the hearing will keep on going.
Yeah.
Right, versus
Oh.
the continuance.
I
Yeah,
mean, why don't we just say will be postponed?
Yeah.
Yeah.
yeah, I
well,
want to say that.
we use that word in, we have to change in other places.
Oh,
Like,
effective
I wouldn't change
continuance.
it everywhere. It's just in this case, it just really sounds like you're saying
Keep
the
going.
hearing will be continued, like keep on going.
Mhm.
Except I agree, then number 5, effective continuance, and probably the term continue or continuance is used throughout.
All
Yeah,
right, go
that's-
ahead.
we do have a responsibility to explain things and answer people's questions. I mean, there's lots of terminology in the regulations.
Okay, that's fine.
Okay, so in that, thus instead of continued, will be placed in continuance? So it shows that's a term of art, or is that too?
I think it's going to be too hard to change it everywhere.
Okay, so will be continued. Okay. Great. So everyone's okay with that. What's the next piece here?
I don't have anything for a while.
Okay, so what page is the next one? I just realized, by the way, that under view, I've been looking at it in like 50% mode. So it's very hard to see. I was squinting at it. I was wondering why I can't set it so small. I just realized I could go in view and expand it to 100%.
oh, Board Member Calavita has a question here. Can you see her comment
Where?
on 7, hearing packet?
How about making it clear
Uh,
complainant can receive packet with anything really confidential? such as-
No, I'll delete that. That was
Okay.
my first go through, Ms. Lee.
Okay,
That's too,
thank you, because
Yeah.
I'm not
It's too
sure that was gonna work.
too complicated. Yeah.
Except isn't this one of the issues that we want to address that we haven't addressed yet about the documents that the complainant gets? They don't get anything, right? I can't find where.
They get under the PRC process, they got their own statement and they got any documents that were considered public records. So they often got police reports. They got some things, but they didn't get everything.
No,
They
but to
got,
me, this is the same issue
policies.
about lack of
Yeah.
due process, that they don't get the officer statement, but the officer gets the complainant statement. they don't get the investigation. I mean, I don't have the chart in front of me, but I know that the last BOI, there was what documents the officer
Right.
received and what documents the complainant received. And it was totally lopsided. So even though we didn't raise it before, and obviously it'll raise the same concerns and meet and confer, but I think we might as well personally go for it and try to make this thing fair.
How about we put this on a list of things to ask the city attorney? I think the answer is gonna be Penal Code 832.7 or 8. I think 7.
But we
Anyway,
won't give the
Code.
person the confidential personnel file, but we don't see the officer's confidential personnel file.
It's
very
the
little-
confidential investigatory materials.
So it's broader, you're saying, is investigatory materials as in, the interview notes, the interview, would that be part of
Interview
the
transcripts.
transcripts?
yeah, Even our report. So,
But the officer gets all that stuff, right?
yes, they do. And this is a
Well-
function of, it's a function of state law. It's the same thing. This is the same issue as how long the complainant can stay in the room.
Well, I think it's a matter of interpretation, especially since we heard at our last meeting that the changes to the process that were so fundamentally changed were made as a result of a meet and confer, and not because of some interpretation of the City of Berkeley decision, which doesn't support that.
Well,
So
that turned out to be wrong, though.
Yeah, I'm not sure that's. true.
That's not what
it's not
happened.
true.
Not true.
Oh, okay. I think that's what Lieutenant Montgomery said. Is he still there?
Yeah, he thought maybe, but it wasn't actually the case.
Oh, okay.
But
well-
I still think you have a good point, Julie, because
I'm here. What was your question?
the question
I heard-
was,
I heard you say at our last meeting that the changes to the old PRC practice were made as a result of a meet and confer after the City of Berkeley decision, and not the result of the city attorney's analysis. And then I was just told that actually that wasn't true. So
Yeah, my understanding is following the lawsuit prior to reopening or beginning hearings again, that there was a meet and confer process between the BPA and the city. And the subsequent changes to the practice of allowing cross-examination of officers was borne out in those meet and confer processes. Prior to that, we were cross-examined by counsel for the complainant.
In private?
okay, well then it sounds like what I was saying was accurate, but
Okay,
I don't know. It's still mysterious, and it would be nice to have some clarification about what actually happened.
so do we, I
Chair,
think,
could I just say that the penal code that was just referred to, 832.7 and 0.8, they list out exactly what it is that's considered confidential personnel items.
Yeah.
And it's things like, misconduct record or medical files, or there's 8 things if I remember correctly. And I don't remember any of these things being involved in interviews with Byron, which is what
Right.
I was proposing with that side comment there. How about making it clear complainant can receive packet with anything really confidential redacted? I mean, if there were some reference to some of those things listed in 832.8,
then you'd go through a
then
redaction
they
process.
could easily be redacted, but the interviews I've seen focus specifically on the incident.
Right.
Yeah, I think this is a important question of substantive matter with regard to confidentiality and personally identifiable information as well. And we want to float this up rather than just address this inside of our regs committee. We want to provide a suggestion again about it. And I think the suggestion of putting it forward to the city attorneys again may be a consideration in the as an addition or a re-emphasis, while bearing in mind that we have a continuing question around who the possible question around who the client is with regard to the city attorney's office and the PAB. what are thoughts on that? I want to make sure Board Member Owens and can't remember who raised their hand first, Ms. Saganor. Do you guys have questions or comments regarding this specific issue?
About the, what the complainant receives. Yes, that's what I wanted to address.
Okay. I don't know who raised their hand first. Okay, Ms. Saganor, please proceed, and then Ms. Board Member Owens.
Okay, so my understanding is that there's going to need to be a meet and confer about changing, having the PAB do something different from what the PRC did in regards to this. But remember, we're not looking at the interim regs now. We're looking at the permanent regs. So whatever it is we put here has no influence over how things are actually conducted right now. And we know that there's going to be probably a very lengthy meet and confer process before the permanent regs are. So we don't really want to say, oh no, we can't put it in the permanent regs because it will trigger meet and confer. It is another area, as Ms. Lefwich points out, where it's really terribly unfair, right? We don't know if there's going to be a hearing, but there may be a hearing, and the police officer will have seen basically everything the complainant had to say, which is going to be, well, what is your perception of what happened, right? And then the police officer can prepare, knowing here's what the complainant is going to say about what happened. And the complainant will not have any clue about what the police officer's perceptions are of what happened before going on to the next stage and going into a hearing. And that seems really, really quite unreasonable. Redacting the police officer's statement is, of course, perfectly suitable, but not allowing the complainant to hear what the police officer said it seems to me kind of counterproductive when you're trying to determine what happened. In some cases, I'll stop there, but you get my.
No, I understand. We're asking a question about.
But the idea that this is going to trigger a meet and confer, I don't think is our concern at this point. We're not working on the interim regs.
Okay, I think that's correct in terms of the procedurally speaking and strategically speaking, to be aware of that we are working on the permanent regs. And again, we're talking about a question about access to materials that might trigger transparency questions that would then be aligned with due process questions in the context of a hearing with two parties or a process with two parties. And a potential solution that's been raised by Board Member Calavita was just redact, instead of providing a broad scope where all investigatory materials, including the totality of the transcripts, would be excluded from the packet, the staff would have the opportunity to redact for potentially confidential information per the reg and the potentially eight or so items that Board Member Calavita referenced in 8032.47.
I wonder if we should reference state law, saying something that is prohibited from disclosure by state law.
Sure. So let's talk about the language, what we might add on, but I also want to hear from Board Member Owens really quickly as well.
Just want to clarify something. So the officer and their representative gets a full hearing packet, which contains everything. The complainant gets a redacted package that doesn't contain everything, correct?
So it sounds like we want to be careful how we're using redacted. So it's a packet where full parts of the investigatory outcome, such as a transcript, are entirely excluded, or whatever you want to call it, exempted from the file as a whole. It's not that you get a transcript and then throughout the transcript is blacked out, which is what we do in my office, my federal agency. We will go through it, and there will be a FOIA person, Freedom of Information Act, who will redact out personally identifiable information and information that regards like continuing an ongoing investigation, for example, that would then impact the enforcement of that case. So it's not that they redact out pieces of documents, they redact out entire documents. So it's a broader scope in that sense. So I do see the concern around that.
The only thing they receive is their own transcribed interview.
They do receive, and I think Board Member Owen still had another comment, but they receive their transcript at minimum. They will sometimes, depending on the case, receive a copy of a police report that's been redacted and is considered a public record. They might receive other investigative materials that we collect that are not deemed confidential. So it depends on the case, but at minimum, they will receive their own transcript.
Okay, but it sounds like as a presumption, the transcript of the police officer's transcript that's out. You don't put that in there.
Oh,
Okay.
that's out, yes.
That's right.
So that is of course going to raise the symmetry concerns around due process. So what can't you have the same effect as with doing the process that Ms. Calavita referenced and which I just referenced as very common in federal and state law enforcement? When I say law enforcement as an attorney review, that you would just redact out within the document rather than redact out wholesale transcripts. So do we need?
Nothing even to redact. There's just this assumption that the entire document is privileged.
Right. So I think this is a scope question that we really have to address because it certainly is a concern for members of the public. We also want it's obviously the balancing of the rights here, of course, but we want it to be very specific to be aligned with actual code or law, state law. And I think aligning it with the 8 or so items under 8032.47 rather than just a broad swath scope of just excluding out the entire transcript and other full investigatory documents, it does not seem to be narrowly tailored or aligned with 8032.47. So I don't know how we're going to frame this language, but.
Well, how about if we say the complainant shall receive a hearing packet without documents protected from disclosure by state law?
Okay, when we start with that. Hearing packet without a containing.
Without documents protected from disclosure by state law.
Okay, so let me ask a question about that.
Without documents, without language. Without, yeah. Is that what you're going to ask Board Member Owen? Sorry to interrupt.
Or without information protected.
Without information. Is that what you were going to say, Board Member Owen?
Hearing back.
Yeah.
Yeah, information is fine.
Okay, because documents still places us back in that
Right.
scope problem,
Right.
the entire transcript being excluded.
And then I'd get rid of containing confidential investigative materials or findings and recommendations. Just get rid of the rest of that.
The complainant shall receive a hearing packet without information protected from disclosure by state law.
I would suggest that we put this in front of the city attorney.
Yeah.
As soon as possible, because this is going to be another one of those.
Okay, so
potentially
put it,
prefer, and this is something we want, so we might as well.
Right.
a good suggestion. So I can, Director Lee, if you could add that there with notation that we're just trying to align it with the specific regulations under 8032.47 with the 8 items. To avoid overbreadth of scope. Penal Code 8032.47 exclusions. I don't know what is it called, confidentiality? Is that, I haven't looked at that. Confidential personnel items. Board Member Calavita, do you remember?
Called personnel records, confidentiality, discovery, exceptions.
Okay, well, they'll figure it out, but yeah. The point is it has to be aligned, so we don't want an overbreadth of scope problem here.
Yeah. Are we
Great.
ready to move ahead?
Yes, I think so. What's the next part? So
Actually
timekeeping
have
is 8 o'clock.
I actually have something on the next section.
Okay, so it's 8 o'clock. Let's try to end at 8:30.
Yeah.
That's 2 hours.
So the next section, what I'm looking at is H, let me see. Okay, no, now it's G, board member impartiality.
G, we're going backwards or forwards?
No, we're going forward.
Okay.
We're going forward, the very next section.
Page
So-
10.
Page
Yeah, but
11.
actually I'm on page 11. The top of 11 says, no member of a hearing panel shall publicly state an opinion regarding policies directly related to the subject matter of a pending complaint. Publicly comment on any facts or analysis or pledge or promise to vote in any particular way. Well, and when I was looking at this, maybe if it says pending, I just thought that was overbroad and that it should be say, shall before or during a hearing publicly comment on something. It just seemed like you can't, I guess if it's pending. I was struggling with this being like in perpetuity, you can't comment on a policy, which seems really broad.
No, this is a pending
But
complaint.
yeah, so never mind.
Okay,
I
great.
take it
Next one.
back.
Oh, cool. Thanks for, but that's important to have a conversation about it. Next one. Where are we at then?
I would like to raise something that's on page 14, that's all about the main issue that we've been talking about, the complainant,
Yeah. The symmetry question.
the symmetry question.
Okay.
And
page
I would
14.
like to air something tonight and get people's feedback on it that will not be decided tonight because I think we're probably waiting on the city attorney's opinion on this matter of whether the complainant can stay in the room. But I actually have come to prefer a different hearing process, which would be kind of a hybrid between what all neighboring jurisdictions do and our current system. So in order to achieve symmetry between the presence of the complainant and the presence of the officer, you know, we've heard a lot about the disparity and inequity of dismissing the complainant when the officer can stay in the room and question the complainant, but not vice versa. And I think that I am beginning to see the writing on the wall that the city attorney may tell us that it is not legal according to state law. I would disagree with that, but I think that they may come to the opinion, the decision that it's not legal to allow the complainant to remain in the room. And then in that case, I would hesitate to go ahead and push it anyway. Even if the city attorney decides that it is legal for the complainant to stay in the room, I would not be surprised if a lawsuit would follow. Because of that, and because of my own questioning what it means for the complainant to sit there and be questioned by the person they're accusing, I would propose a kind of hybrid where we interview each side separately. The complainant comes in, tells their story, we interview them, we ask them questions, and then they're dismissed. Then the officer and their representative comes in, we question them, we interview them, and then they leave. So that we would have a system that's equitable and a system that, for example, does away with the intimidation factor that we've heard some former complainants talk about, being intimidated by being questioned by officers they're accusing. And, you know, no other jurisdictions in our neighborhood have this system where we have officers questioning the complainant. And I think this would solve a number of issues. It's clearly legal and clearly does not violate the Peace Officers' Bill of Rights, as seen by the fact that other jurisdictions do it this way or some version of this way. And so that would be my my proposal. And,
think that's-
you know, it's just to talk about it tonight because I know people want to hear from the city attorney's analysis, but even if the attorney says that we can go ahead, we're going to have a lawsuit.
Yeah, I think that's a really good suggestion. It's innovative as well. I'm thinking about the pragmatic aspects and strategy in terms of making sure the PAB is not hand tied in terms of being able to process cases. But I also want to ask a quick question here, and I see Board Member Leftwich and also Ms. Aguilar also has a question as well. We want to make sure to have this all out and open. One question is, does that mean then the being independently questioned, and it also comports with you're saying neighboring jurisdictions, I assume they're police review commissions or the independent
Their oversight bodies.
Civilian oversight.
oversight bodies in San
Oversight
Francisco,
bodies, San
Oakland, or-
Francisco,
Okay.
Francisco, BART, Oakland, San Jose.
Okay, so there's some form of symmetry there, but does it also mean, just following along this line of symmetry, that the officer then cannot then later on request that their counsel or themselves, quote unquote, cross-examine the complainant or vice versa?
That's right.
Okay, so both parties are on equal plane in that sense. And
Yes.
do you envision a possibility of like the complainant and or the police officer not verbally and in person questioning or cross-examining, quote unquote, cross-examining the other party, but doing so through interlocutory, like questions, written questions?
No, I hadn't thought about that. No. I mean, I suppose one could incorporate that into it, but you mean written questions to the other side?
Yeah, do some form of process. I'm just thinking through potential questions on whether or not this is truly symmetrical, and also the question of truly accessible by both parties.
I'm just imagining parallel interviews before the panel.
Okay. Thank you. Board member, I think it was Board Member Leftwich and then Ms. Aguilar.
Yeah, I actually had the same thought. I was thinking about that this morning, but then I remembered that we talked about this option a couple of months ago, and I thought somebody from the department said that officers have a right to cross-examine somebody who's making an accusation against them.
There is
So,
nothing. Yeah.
So there's no, under POBRA. I
There
don't
is
know if
nothing in the Peace Officers Bill of Rights about cross-examining or questioning.
I'm
And
just saying
furthermore,
somebody said that at one of our meetings.
I remember,
Sure, I
but
recall
it's
that.
not in the document. And since no other place does it, I have to imagine it's not.
Yeah, I don't know. So there's that. But I do agree in theory that that's a good solution. But I also don't want us to be afraid of lawsuits.
Yeah, no, of course.
You know, it's not the end of the world if there's a lawsuit. And I do think that it's an incorrect position, and maybe even if it isn't an incorrect position, that you have a good solution and that would be the best
Right.
thing. But we still may end up with a lawsuit, is all I'm saying, unless the department says, sure, that works for us. So I don't want us to be too afraid of lawsuits. And, you know, we do have a right to independent counsel.
That's
If
right.
there's a conflict, so we need to keep that in mind too.
I do understand not being afraid of lawsuits, but the more I thought about this, the more I thought it was actually a better version, because I know when, you know, we've heard Moni Law, who is one of the complainants who's talked to about her experience, and at least as much about her experience had to do with how intimidating it was to be questioned by the officer, even more so than being dismissed afterwards. That was, and so I see no necessity for it, and it solves a lot of issues.
Yeah, I see what you're saying. So the one thing that we kind of have to remember is that on the one hand, the complainant, if for symmetry purposes, of course, the complainant can be questioned by the officer. In addition to, she can question the officer. So it goes both ways. And given the relative power dynamic, that can be intimidating and potentially chill someone's speech.
Yeah.
Okay, thank you.
I
That's a
would
good
just
reminder.
suggest that we say that we can then, if we make that change, that we can then recall the complainant after, if we, interview the complainant, then interview the officer, that we may have some follow-up questions. It might just not be a one and done.
Sure. Yeah, I think that would make sense. And we will find out from Investigator Norris if that's necessary to add that language or if that's assumed in the process. It can be more than one time. Ms. Saganor? Or
I think that this is a better way to do it. And I remember being sort of disappointed that it was dismissed as a possibility sort of at one point, because among other things, even if you say, well, both sides can question the other side, being the person that speaks second is a really large advantage, where you've actually heard what has been said, and now you can, if you want to, emphasize certain points or not emphasize other points based on what has already been said. So if neither party is in the room to hear what the other says, you really have better symmetry. There isn't the same kind of first and last in the same way.
If they get the documents, if the complainant gets the documents, because if the complainant isn't getting the officer's statement, then the complainant is still
full
more in the
information.
dark.
Well, yes, exactly. But if they can question each other, but the complainant doesn't get the documents, then it's even worse. They didn't get to see in advance what the officer has to say. They don't get to hear what the officer has to say. They're really in the dark about what's being said.
Sure. So
by the officer. So
the principle of the symmetry has to align from front to end.
right. I think both of these are important, but in terms of the actual hearing, being able to, neither side hearing what the other side says in the room, right, is a lot more fair. And about the officers being able to ask questions, I'm wondering if it wouldn't make sense that each side, both the complainant and the officer and their representatives, might be able to request that the board ask particular questions, so that I'm not going to be in the room, but I would like for the board to ask a particular question, or the officer could do the same thing of requesting that a question be asked. And then the board could decide whether or not it's really a relevant question.
Right.
Yeah, so that's a possibility with the interlocutory kind of aspect of that, because that could be a question that, okay, you have each other independently come and talk to the quote unquote neutral party, which is also part of this too. I want to enforce that. In my feeling, at least, having this type of practice that Ms. Calavita is referencing could also emphasize that this is not supposed to be an adversarial context, in the sense of, while the officer is being investigated based upon a complaint, the Police Accountability Board is an independent and quote unquote neutral party. It's not like a prosecutorial body. And so I think when we have these situations where, can this person quote unquote cross-examine the other person, but only the law enforcement officer can ask questions of the complainant, it certainly sounds like an adversarial situation that is described as non-adversarial. So that's troubling in terms of a symmetry due process. So this would kind of bring this in line with that, with a neutral fact finder, independent counsel. But that issue of I think we'll have to hammer out a little bit more as well. But I like that, what Ms. Saganor noted about, they can possibly give the board questions to ask. And we have to kind of process that through our procedures, ensure that the questions are not only relevant, but also come from a neutral fact finder type of perspective.
Right. And which truly makes the most sense anyway, in that it's the board that's going to be making the decision. And as you say, this is not a court of law. It is the board's trying to determine what happens. So really it's the board that needs the full set of information.
Right.
So they need to know they'll know what it is they need to know. Okay, thank you.
Thanks. Board Member Calavita, you have your raised hand, so hand raised.
Oh, I'm sorry. I just left it up by mistake. So
Sure.
it sounds like there's some interest in this possible model, and if it would be helpful, I doubt that we're not gonna, settle on something tonight, but maybe I could draft some language for this section to see if
Sure.
it's something that people,
That'd be
for
great.
next time.
And then
Yeah.
before I go
Yes.
to investigator, please do that, and we appreciate that. And before we go to investigator Norris, I think we also want to remember Director Lee to flag this for the city attorney's office. As board member Owens reflected, just as not because we're afraid of being sued or whatever, but because we want to know whether or not they have an opinion on it as we move forward in our permanent regulations.
You talking about
Also, we
flagging?
need to know what the department, I mean, I feel like we don't have a good sense unless there's some lawsuit or demand for meet and confer, what the department thinks. It'd be kind of nice to know now or soon after we have some language, what the department thinks about it, right? Because if they're cool with it, then we can carry on. But
Yeah, Lieutenant
I
Montgomery.
don't know why they're not telling us. I mean, I think we're entitled to have their opinion before they file a lawsuit.
Sure. Would you, Lieutenant Montgomery, be able to have Chief Lewis's response either by proxy or directly, some kind of opinion on this?
So I think the term "the department" is being sort of loosely talked about when we're talking about the BPA, the Berkeley Police Association. The departments, the things that you're saying about having two separate kind of interviews, there are some issues there that may become issues. What I was thinking of while you were talking about it is that if new information were brought to light that would either sort of compromise the officer's credibility, but the officer would be able to offer proof to the panel that that was an incorrect statement, and they weren't aware of it because they weren't in the room and they hadn't heard it, then the panel might be left with the sort of a bias towards that information that could be disproven by the officer, and the officer and their representative be completely unaware of it. So that's sort of problematic about excusing the officer. But I just want to make clear that I'm here to represent the department, and I'm not speaking for the union.
Sure.
I'm just
Thank you
kind of
for
calling out issues that I do have some insight having been an officer, so I can call up the issues for consideration, but not taking a position of the union, and that would be sort of implied when you're talking about whether or not it would cause them to trigger a lawsuit or something of that nature.
Okay, thank you. That's really helpful. And those are, kind of more, I don't want to say they're not important. They're micro issues in the sense of this is a macro that we're trying to move it forward. And then those are issues we'll deal with as they come up. And it's important to be aware of them as well. As we talk about this language and as board member Calabrese drafts language.
It fundamentally feels, that suggestion feels less off track than we were with the other proposals.
Okay, thank you. Investigator Norris has had his hand up for a while, and then board member Leftwich. And it's also time check is 8:20.
I am generally in favor of board member Calabrita's idea of separating the parties and having the board talk to one at a time outside the presence of the other. I think that brings a little more parity. I think that could be a fair compromise. I don't know what the union would think of that. But I want to ask you, Kitty, you referred to parity of, not parity, but you talked about other achieving symmetry with other jurisdictions. But my understanding is that BART, the Rich process, the board never meets with its complainant.
No. So what I said was this would be a kind of hybrid. But my point was, in other jurisdictions, there's never a moment where the officer cross-examines the complainant.
Oh, so you're just being specific to that?
They don't have hearings such as they don't have hearings like we do.
No, they
But
don't.
it's more like what you do with interviewing officers and complainants, and you do so separately.
Yeah. And I just want to say, it is just as a comment, I mean, there's been lots of criticisms of our process, and it's not that I don't think it needs some changing and tweaking here and there, but our process is in some ways more advantageous than other systems, for example, like BART. Again, their board never meets with their complainants. Our commissioners throughout the years have actually, they have a chance to talk directly to our complainants after our investigation. And I just want that acknowledged, because there's been so many statements and misrepresentations of the record of the PRC that's existed for 40, 45, 50 years. And I have to say, I take a little umbrage to that, of the work that commissioners have done throughout the decades providing service to the community and working with the police department and the union to improve policies and get to where we are. So it does bother me when things are distorted and misrepresented. And just quickly, I'm not going to get into a tit for tat with Ms. Melanie Law about her experience. I will say that her experience did not represent the experience of most of our complainants. And I was there at that hearing. And I'm not going to go into it, but I will just say that I don't think her behavior or the behavior of her attorney was appropriate as well. And that's all I'll say on that. So please, as you hear these things, question people, ask questions, don't just take things as fact.
Absolutely. Thank you, Investigator Norris. And, we greatly respect the work that both you and Director Lee do, and the amount of effort it takes. I conduct dozens of investigations a year. I know how hard it is myself. But
it wasn't just about staff. I mean, to me, it represents the serious work that commissioners have done for years on the PRC and worked with this department. Anyway, I made my point.
No, and I hope you understand that we're coming from it from a principled standpoint, that we're trying to assert certain modern due process standards. And then here we're having this conversation. It's a healthy conversation, and make sure that all stakeholders are here. Also encouraging, again, the BPA to come to these meetings too, to ensure that we understand where they're coming from, so that there's not a big surprise at the end. But when they're involved, they have a position at the table with us, like the way that we have with Lieutenant Montgomery, to have a full conversation and learn things too. We might not be doing things in a way that makes the most sense, because we don't have a very important voice here too. So I think Board Member Leftwich is next, and then Board Member Calavita, and then a time check is 24.
This is kind of, it's not unrelated, but it's not related to what we were just talking about. And it's just that I don't have a good understanding of how unions work. And so Lieutenant Montgomery was saying we need to make a distinction between the department and the union. And I guess I'm kind of surprised, but maybe I shouldn't be, that if the department was fine with something, that the union would still potentially file a lawsuit about it. And maybe, again, that's just my own ignorance. So if somebody could just explain how that works, it would seem to me that a union would be checking with its members, and maybe they don't, want to do a questionnaire for every member, and they're out on their own just thinking, how they should be the most vigorous advocate. But it still seems surprising to me if the staff that we're dealing with and the chief would be fine with something, that the union still might file a lawsuit over it.
Well, sometimes the union might be at odds with the department, or have a different opinion than the department has, or the city council. So the union represents the interests of the membership in all their working conditions, and we are not always aligned. So there are two separate groups, and the department may or city may impose something, and the union may have to take issue with it and avail themselves of process that would be against the department or the city.
Yeah, that makes sense. And Lieutenant Montgomery, is there a current, there's a collective bargaining agreement that's in place? Is that correct?
Yes, sir.
Okay.
I just still think it would be helpful for us to get input from the department on the things, because I think in my experience, we've worked very well with the department. And I'm not happy that things have become more adversarial, because I think we've had a lot of great back and forth and worked well together. So I personally would like to know the department's thoughts on some of these things, and not just be hearing from the union, because they are distinct.
Yeah, so you haven't heard from the union. They've held themselves out of this process. I'm here representing the department, representing the chief. To the extent that I know the chief's preferences, or I can answer questions, I'm happy to do that. I just would ask for the grace if I have to take it back and ask the chief when I'm not clear. I don't want to misspeak on her behalf.
Sure.
But I'm happy to ask clarification questions or maybe give insights as needed, as long as if you accept my limitations.
Yeah, thank you. You've been helpful, and we appreciate your attending all these meetings. I think Board Member Owens had her hand up, then put it back down. Did you?
I think Lieutenant Montgomery is, I think what he's saying is the department and the union are two separate entities. I mean, I've worked at a police department. I know that there are oftentimes that the chief and the executives in the police department have one opinion and the union has another, and they end up basically going through the same process we're going through, which is a meet and confer, blah, 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 blah. So the union operates independent of the department in a lot of ways. Sometimes they're aligned, sometimes they're not. So it is good to hear from Lieutenant Montgomery, to hear the perspective of the department. But I understand what he's saying about he doesn't speak for the union, because the union, they represent their membership. And Lieutenant Montgomery is no longer part of that union because he is now a lieutenant. Correct me if I'm wrong.
Yeah, that's incorrect. I'm a member of the union.
Oh, okay.
Yeah, we're members of the union. We can't be members all the way through chief, but
That's unusual.
That is unusual.
So is that Lieutenant Montgomery, just to follow up from Board Member Owens, and again, time check is 8:28. Do you think that there could be some hesitancy for the BPA to be present because you are the representative of the chief, essentially? Your representation is for the management.
no, they've taken the sort of relevant steps to initiate a meet and confer.
Okay.
And that's a negotiation between the city and the union.
Okay.
The chief, for example, is not necessarily a party to that. So they're now kind of taking up some of the issues in that meet and confer process where they view as appropriate to take it up.
Okay. So
And
they selected their
consequently,
venue.
that removes them from this process.
Okay, the help. Thank you for the clarification. That makes sense, which I didn't think of until just now. But in the future, we certainly hope that they will continue to engage with us, outside of the meeting confer or after the meeting confer.
There's a lot of work that's going to have to be done, so we can talk offline.
Okay, thank you, Administrator Norris.
Really want to get to the heart of the matter.
Thank you. So good. It's 8:29. We got a lot of work done today. Good job. I want to make sure we tie up any loose ends before I close out this section of the agenda. Is there anything else that we missed?
Oh, I just want to tell Kitty, I have from 2007 some old administrative hearing procedures from the Oakland Citizens Police Review Board. That's since gone out of existence, but it detailed their process at the time for handling complaints, and their process involved hearing from one party at a time and then excusing them and then hearing from the other party. So I can give that to you as a sample.
Sure, you
Yeah.
can send it to all of us if you like. I don't know if that's appropriate. Is that appropriate? Yeah. Kathy?
Sure.
Yeah, I mean, the fact that there's so many jurisdictions that do it this way.
So many?
Huh?
Did you say so many?
Yeah,
That's okay.
There's a lot. Okay. Yeah.
All right. I was just, okay.
what I mean is the ones that they don't have a hearing like ours.
Yeah.
But they have parallel interviews, is my point.
Yeah,
And
but
the fact that there's no cross-examination.
Bart's board does not meet with the complainant at all. That's what I was trying to tell you earlier.
No, but somebody does.
The Kathy's position during the investigative process, but the board does not.
The investigation process involves parallel interviews, is my point, and there's never a moment of cross-examination. That's my only point.
Thank you. We look forward to receiving those materials, Investigator Norris.
Okay.
So if there's no leftover things that are strings to tie up that I've forgotten, then we'll proceed to 5 and then move to public comment, which I don't think there are any members of the public. Okay.
How about the next meeting date?
Yes, schedule next meeting date.
I think everybody was available November 2nd or 3rd, and that's a Tuesday or a Wednesday.
Yes.
So do I hear any
I would
preferences?
prefer Tuesday, everything else being equal, but I don't have super strong feelings about it if anybody else does.
I also prefer the Tuesday.
Yeah, that's fine with me.
Could I just ask, there's no time sooner than that we can meet? I thought we were trying to meet every 2 weeks.
I think there was not.
Okay,
And we should probably go ahead and just schedule more meetings because we're not going to be done with one more meeting either.
Should we meet on both the Tuesday and the Wednesday in November? 2 days in a row?
Oh my God, no.
no, but the
No.
Tuesday, the 26th was not an option, Kathy?
The 26th, no.
Okay,
I think you were the only person who said that. Well, I guess once.
Can we talk about it now? Can we ask everybody now? Are they available on the 26th? We're all here, right?
Right. I think Julie was not available. Was that right?
What day of the week is that?
Tuesday.
So
I'm
I
not sure.
also
Maybe
have-
I am. Am I the only holdup? I can go check something.
I also have a meeting at 7:30 though. It's typically a 1 hour.
Oh, so maybe it was Mike that was the,
The 19th is out as well.
The 27th is open though. The 19th.
27th.
No, the 27th is your regular meeting.
PAB.
Oh, okay.
The 19th is a week from today. I guess that's out.
That's open for me, but then maybe someone else may have a conflict.
Not for me, but the 20th is open. Does anybody have open the 20th?
is that a Wednesday?
That's
It's
a
Wednesday.
Wednesday.
Yes,
Yeah,
I
I've
can.
got another.
Okay, I guess that's,
So was the 19th open though? I'm just trying to just figure.
No,
no,
Okay,
no.
so the 20th,
Wasn't
I'm
open.
available, the other people cannot, that's fine.
The 26th. was-
So I think Kathy did go through this whole process. This is what we're finding out.
Okay,
The 26th from 7:30 to 8:30, I have another meeting.
and Mondays are out?
Mondays are
Not
out
for me.
for me.
Okay,
Mondays are out for Cheryl.
Okay.
So how about we just stick with our November 2nd? It looks
all
like
right, I can do that.
Okay,
And then schedule a few more if we could.
Okay.
yeah, would you mind doing that?
No,
Coordinating
I will do that.
directly? Thank you.
I'll
Okay, so November 2nd at 6:30 is the next one, and then we're gonna schedule out probably need like 2 or 3 more, but we'll try to power through this with 2-hour increments and not,
Yeah.
we don't need to go on for weeks and weeks, but we'll get down to the point. We have some traction now, I feel.
Yes.
So there doesn't seem to be any public participants.
No,
Okay, so there's
They're all
someone,
at the council meeting.
all right, that's right. Oh, you're right, yeah.
oh, yeah.
Or at the baseball game. Would someone like to move to adjourn?
So moved.
Seconded.
Okay, great. So we are adjourned, not seeing or hearing anything otherwise. Thanks, guys.
Okay.
Very
Thank
much.
you.
Everybody.
Thank
Bye.
you. Night.
Thanks, everyone.
Bye.